Dear learners, welcome to my channel Educare Horizon. In this video, we are going to discuss Industrial Disputes Act 1947. The Industrial Disputes Act 1947 was passed with a view to removing certain shortcomings of the Trade Dispute Act 1929. The act came into force on the first day of April 1947. Objectives of the act. The main objectives of the Industrial Disputes Act 1947 are to secure industrial peace by preventing and settling industrial disputes between the employers and workmen, by securing and preserving amity and good relations between the employers and workmen through an internal works committee, and by promoting good relations through an external missionary conciliation, courts of inquiry, labor courts, industrial tribunals, and national tribunals, to ameliorate the conditions of workmen in industry by redressal of grievances of workmen through a statutory machinery and by providing job opportunity. So the Industrial Disputes Act was passed by the central government in order to remove the shortcomings or limitations of the Disputes Act, Trade Disputes Act 1929. The Act, Industrial Disputes Act 1947, came into force on the first day of April 1947. The main objectives of the Industrial Disputes Act 1947 are to secure industrial peace by preventing and settling industrial disputes between the employers and workmen. So the main objective of Industrial Disputes Act 1947 is to promote industrial peace by preventing and settling industrial disputes between employers and workmen, by securing and preventing good relationship between the employers and workmen through an internal works committee. The another objective is to ensure and preserving amity and good relationship between employers and workmen through an internal works committee, by promoting good relations through an external missionary conciliation, courts of inquiry, labor courts, industrial tribunals, and national tribunals. A second objective, to ameliorate the conditions of workmen in the industry by redressal of grievances of workmen through a statutory machinery and by providing job security. So the ultimate objective of Industrial Disputes Act is to provide industrial peace by reconciling the issues or creating a good relationship with the help of internal works committee and some other external dispute redressal forums, and to ameliorate conditions of workmen, to provide better working conditions, to resolve the grievances of the workmen, and providing job security. Let us see the important definitions. First one is industrial dispute, section 2 subsection K. So section 2 subsection K of the Industrial Disputes Act 1947 defines what is industrial dispute. According to section 2K, industrial dispute means any dispute or difference between employers and employees, or between employers and workmen, or between workmen and workmen, which is connected with employment or non-employment, or the terms of employment, or with the conditions of labor of any person. So this is the definition for the term industrial disputes. According to section 2 subsection K, industrial disputes means any dispute or difference of opinion between employers and employers, or between employers and workmen, or between workmen and workmen, which is connected with, the difference of opinion is connected with employment or non-employment, or in terms of employment, or with the conditions of labor of any person. So this is the industrial dispute means any dispute that is related to the employment or non-employment, or the terms of employment, or with the conditions of labor of any person, between employer and employer, or between employers and workmen, or between workmen and workmen. Industrial and collective disputes. So let us see what is industrial dispute and collective dispute. So industrial disputes may be broadly divided into individual disputes and collective disputes. Section 2 subsection A provides that where any employer discharges, dismisses, retrenches, or otherwise terminates the services of an individual workman, any disputes or difference between that workman and his employer connected with or arising out of such discharge, dismissal, retrenchment, or termination shall be deemed to be an industrial dispute, even if no other workman nor any union of workmen is a party to the dispute. So section 2A defines that where an employer discharges or dismisses or retrenches or otherwise terminates the service of an individual workman, any dispute or difference between that workman and his employer connected with or arising out of such dismissal or discharge or retrenchment or termination shall be deemed to be an industrial dispute, even if no other workman nor any union or of workmen is a party to the dispute. Then a collective dispute may relate to any of the following matters. First one, wages, bonus, profit sharing, gratuity, compensatory or other allowances, or hours of work, leave with wages, holidays, or rules of discipline, retrenchment of workmen, closure of establishment, rationalization, etc. A collective disputes are industrial disputes. So collective dispute means any dispute which are related to the following matters, like it may be related to wages, bonus, profit sharing, gratuity, compensatory and other allowances, or hours of work, leave with wages, holidays, rules of discipline, retrenchment of workmen, closure of establishment and rationalization. So any dispute which are in nature related to the wages and wage related issues, or related to the services or retrenchment of services, that will be coming under the collective dispute. All collective disputes are industrial disputes. Then section 2 subsection CC defines closure. According to section 2 subsection CC, closure means the permanent closing down of a place of employment or part thereof. So closure means permanent closing down of a place of employment or a part thereof. The next definition, very important definition, that is layoff. Section 2 subsection triple K defines what is layoff. According to section 2 triple K, layoff means the failure, refusal or inability of an employer on account of shortage of coal, power or raw materials, or the accumulation of stocks, or the breakdown of machinery or natural calamity, or for any other connected reason, to give employment to a workman whose name is borne on the muster rolls of his industrial establishment and who has not been retrenched. So according to section 2 triple K, layoff means the failure or refusal or inability of an employer to provide employment to his employees whose name is borne on the muster rolls of his individual establishment and who has not been retrenched due to the non-providence of or failure to provide employment due to the shortage of coal, power or raw materials, or the accumulation of stock, or the breakdown of machinery or natural calamity, or for any other connected reason. So due to the inability of the employer, mainly due to some unforeseen reasons which are beyond the control of the employer, like due to natural calamity or breakdown of machinery or shortage of coal, power or materials or accumulation of stock. The inability of the employer to provide employment to the workman whose name is borne on the muster rolls of his industrial establishment and who has not been retrenched during at the period of such layoff. Then what are the essentials of layoff? So the following are the essentials of layoff. First one, there must be failure or refusal or inability of the employer to continue employees in his employment. Second one, the employees laid off must be on the muster rolls of his establishment on the day of layoff. The third point, the failure or refusal or inability to provide employment may be due to shortage of raw materials or accumulation of stock or breakdown of machinery or natural calamity or some other reasons. And the employees must not have been retrenched. The following are the essentials. First point is there must be failure or refusal or inability of the employer to provide employment to his employees. So definitely there should be a situation that the employer is unable to or refuse to or unable to provide employment to his employees. The second one, the employees laid off must be on the muster rolls of his establishment at the day of layoff. The name of the employees must be there in the muster rolls or the register of the employees at the day on the day of layoff. And the failure or refusal or inability to provide employment that is due to shortage of raw material or power or coal or breakdown of machinery or accumulation of stock or natural calamity or some other reasons which are beyond the control of the employer. And the employees must not have been retrenched on the day of layoff. These are the essentials of layoff. The next important definition, that is section 2 subsection I, lockout. Section 2 subsection I defines what is lockout. According to section 2 subsection I, lockout means the temporary closing of a place of employment or the suspension of work or the refusal by an employer to continue to employ any number of persons employed by him. Lockout means the temporary closing of an employment or the suspension of work or the refusal by an employer to continue to employ any number of persons employed by him. So see, this is a definition. Lockout means temporary closing of a place of employment or the suspension of temporary suspension of work or the refusal of work to the employer to continue to employ any number of persons employed by him. So whenever the company is unable, suppose they are temporarily closing down or suspension of work or refusal of work to the employee by an employer, or see the employer is unable to continue to employ any number of persons employed by him. Such situation we can say it is a situation of lockout. Then we will discuss what are the essentials of lockout. So these are the following features of lockout. First one, there is a temporary closing of the place of employment or suspension or withholding of work by the employer in some form. Second one, there is an element of demand for which the place of employment is locked out or closed. And third one, there is an intention to re-employ the workers if they accept the demands. So essentials, the first one is this: there is a temporary closing of place of employment or suspension of work or withholding of work of employer in some form. The second point is there is an element of demand for which the place of employment is locked out or closed. The employees or employers, see, they have some demands. Due to that demand by the employee side or from the employer side, see, especially we can say from the employee side, maybe they are demanding some increase in wages or see benefits or whatever it may be. See, the employer forced to lock down the business or closing the business, and there is an intention to re-employ. Definitely there is an intention of the employer to re-employ the workers if they accept the demand. So we can say lockout is a weapon, see, in the hands of the employer. The employer can go for lock down the business due to some disturbances from the employee or due to some demand from the employees. So temporary closing down or suspension or withholding of work, and see in such a situation that the employee is demanding something and the employer is ready to re-employ the workers if they accept the demands. See, we will discuss lockout is employer's weapon. There is one case, Kalbretta Estate versus Rajamanikam. In Kalbretta Estate versus Rajamanikam, the Supreme Court observed that lockout can be described as antithesis of a strike. Just as a strike is a weapon available in the hands of employees for enforcing their industrial demands, a lockout is a weapon available to the employer to persuade by a coercive process the employees to see his point of view, to accept his demand. So as per this judgment, lockout will be treated as a weapon of the employer, or it is a weapon in the hands of the employer to persuade the employees to continue his work. So as per this judgment, Supreme Court observed that lockout can be described as the antithesis of strike, because strike is a weapon in the hands of the employees for enforcing their industrial demands upon the employer. Just like strike, lockout is a weapon available to the employer to persuade by coercive process to the employees to see his point of view, to accept his demand. So we can say, see, lockout is a weapon in the hands of the employer to persuade the employees by coercive process to accept the demands of the employer. Then we will discuss settlement. Section 2, subsection P of the Industrial Disputes Act defines settlement. According to section 2, subsection P, settlement means a settlement arrived in the course of conciliation proceeding and includes a written agreement between the employer and workmen arrived at otherwise than the course of conciliation proceeding, where such agreement has been signed by the parties thereto in such a manner as may be prescribed, and a copy thereof has been sent to an officer authorized in this behalf by the appropriate government and conciliation officer. So according to section 2, subsection P, settlement means a settlement arrived at the course of conciliation proceedings and includes a written agreement between the employer and workmen arrived at during this settlement. An agreement has been signed by the parties involved in this settlement, and a copy thereof shall be provided to the officer authorized by the appropriate government and to the conciliation officers. So settlement means an agreement arrived after the conciliation proceedings and signed by the parties, and a copy should be forwarded to the government, officer appointed by the government and the conciliation officers. Then we will discuss another important definition, that is strike. Section 2, subsection Q defines what is strike. We already described that strike is a weapon in the hands of the employees to enforce their demands. According to section 2 subsection Q, strike means a cessation of work by a body of persons employed in an industry acting in combination, or a concerned refusal of any number of persons who are or have been so employed to continue to work or to accept employment, or a refusal under a common understanding of any number of persons who are or have been so employed to continue to work or to accept employment. So this is the definition for the term strike. Strike means, anyway, it is cessation of work, stopping of work by a body of persons employed in an industry. A body of persons employed, cessation of work, stopping of work by a body of persons employed in an industry. Means trade unions or a body of persons employed in an industry. Or a concerned refusal by any number of persons who have been employed in a particular place of employment, or refusal by common understanding of any number of persons. Cessation of work under a common understanding of any number of persons who are or have been employed in the place of business to continue to work or to accept employment. So that is called as, see anyway, this is stoppage of work or cessation of work by the employees. See, we can say collectively as a union, or we can say by common understanding of any number of persons employed in the place of work. Then another definition is workman. Section 2 subsection S defines who is workman. According to section 2 subsection S, workman means any persons, including an apprentice, employed in any industry to do any manual, unskilled, skilled, technical, operational, clerical, or supervisory work for hire or reward, whether the terms of employment be expressed or implied, and for the purposes of any proceedings under this Act in relation to an industrial dispute, includes any such person who has been dismissed, discharged, or retrenched in connection with or as a consequence of that dispute, or whose dismissal, discharge, or retrenchment has led to that dispute but does not include any such persons who is subject to the Air Force Act 1950 or the Army Act 1950 or the Navy Act 1957, or who is employed in the police service or as an officer or other employee of a prison, or who is employed mainly in a managerial or administrative capacity, or who being employed in a supervisory capacity draws wages exceeding 10,000 rupees per month, or exercises either by the nature of the duties attached to the office or by reason of the powers vested in him functions mainly of a managerial nature. So according to section 2 subsection S, workman means any person including an apprentice employed in an industry who is performing either manual or skilled or unskilled or technical or operational or clerical or supervisory work for hire or reward, whether the terms of employment is express or implied. So workman means any person employed including the apprentice in a business, in an industry, whether whatever may be the job, whether it may be the nature of manual work or maybe skilled work or unskilled work or technical work or operational work or clerical work or supervisory work, for hire or reward, whether the terms of employment is expressed, that means written or implied, and for the purpose of any proceedings under this act in relation to industrial disputes, includes any such person who has been dismissed or retrenched or discharged in connection with or consequences of that dispute. So any person who is involved in dispute, who has been dismissed or retrenched or discharged in connection with or consequence of with that industrial dispute, or holds such a dispute or discharge or retrenchment has led to that dispute. So definitely there will be an industrial dispute, and see, in that industrial dispute, workman means any person, including an apprentice, employed in an industry to do any kind of work, either manual or skilled or unskilled or technical or operational or clerical or supervisory work, for hire or reward, whether terms of employment is written or implied. But this workman does not include any such person coming under the following category. First one, who is subject to the Air Force Act 1950 or Army Act 1950 or Navy Act 1957, or who is employed in the police service or an officer or other employee of a prison, or who is employed mainly in a managerial or administrative capacity, or who has been employed in a supervisory capacity, draws more than 10,000 rupees per month, or exercise either by the nature of the duties attached to the office or by reason of the powers vested in him, functions mainly of managerial character. So the workman does not include a person who is coming under Air Force, or Air Force person employed in Air Force, or a person employed in Indian Army or Indian Navy, or a police officer, a person who is in police, or a person working in prison, or a person working as an administrative or managerial capacity, or a person who has withdrawing more than 10,000 or more than 10,000 rupees per month, or exercise any duties attached to the administrative and managerial functions in nature. So this is the definition of workman, section 2, subsection S. Then we will discuss a reference of certain individual disputes to grievance settlement authorities. So reference, we have to refer certain industrial disputes to the various industrial dispute settlement authorities. According to section 9C, setting up of grievance redressal machinery. Every industrial establishment employing 20 or more workmen shall have one or more grievance redressal committee for the resolution of industrial disputes arising out of individual grievances. Second one, the grievance redressal committee shall consist of equal number of members from employer and workmen. The chairperson of the grievance redressal committee shall be selected from the employer and from among the workmen alternatively on rotation basis every year. The total number of members of the grievance redressal committee shall not exceed more than 6, provided that there shall be, as far as practicable, one woman member if the grievance redressal committee has 2 members, and in case the number of members are more than 2, the number of women members may be increased proportionately. Notwithstanding anything contained in this section, the setting up of grievance redressal committee shall not affect the right of the workman to raise industrial dispute on the same matter under the provisions of this Act. The grievance redressal committee may complete its proceedings within 30 days on receipt of a written application by or on behalf of the aggrieved party. The workman who is aggrieved of the decision of the grievance redressal committee may prefer an appeal to the employer against the decision of the grievance redressal committee, and the employer shall, within 1 month from the date of receipt of such appeal, dispose of the same and send a copy of his decision to the workman concerned. So these are the provisions related to the setting up of grievance redressal machinery within an industrial organization. So as per this section 9 subsection C, every industrial establishment who are employing 20 or more workers are required to constitute one or more grievance redressal committee for resolution of the disputes arising out of individual grievance. And the grievance redressal committee shall consist of equal number of members from both the employer side and workman side. And the chairperson of the grievance redressal committee shall be selected from the employer and from among the workmen alternatively on rotation basis every year. So that means, see, suppose we are any industrial undertaking, we are employing more than 20 or more than 20 workers or workmen. So it is compulsory to constitute one or more grievance redressal committee. And that committee consists of members from both from the employee side and employee side. Equal number of members from employer and employee side. The chairperson of the grievance redressal committee selected alternatively from the employer and employee side every year. And the total number of the member of the grievances committee shall not exceed more than 6. And in case, as far as practicable, see, we are required to include 1 woman member if the grievance redressal committee has 2 members. And in case the number of members are more than 2, the number of women members may be increased proportionately. And notwithstanding any provisions contained in this section, the setting up of grievance redressal committee shall not affect the right of the workman to raise industrial disputes on the same matter under the provisions of this Act. The grievance redressal committee may complete the proceedings within 30 days of the receipt of a written application by or on behalf of the aggrieved party. And the workman who is aggrieved of the decision of the grievance redressal committee may prefer an appeal to the employer against the decision of the grievance redressal committee, and the employer shall, within 1 month from the date of receipt of such appeal, dispose of the same and send a copy of his decision to the workman concerned. So these are the procedures. These are the matters related to the setting up of grievances redressal committee. Then we will discuss what are the procedures for settlement of industrial disputes and its authorities. Procedure for industrial disputes, settlement of industrial disputes and authorities. The Act provides an elaborate and effective machinery for bringing about industrial peace by setting up various authorities for the investigation and settlement of industrial disputes. These authorities are as follows. First one is Works Committee as per section 3, Conciliation Officers section 4, Board of Conciliation section 5, Court of Inquiry section 6, Labor Courts section 7, Industrial Tribunals section 7A, and National Tribunals section 7B. So the Industrial Disputes Act 1947 provides an elaborate and wider effective machinery for the settlement of industrial disputes. And these various authorities for industrial disputes, settlement of industrial disputes are as follows. First one is Works Committee. Second one, Conciliation Officers. Third one is Board of Conciliation. Fourth one is Court of Inquiry. Fifth one is Labor Courts. Sixth one, Industrial Tribunals. And seventh one, National Tribunals. The Industrial Disputes Act 1947 provides for the following modes of settlement of industrial disputes. First one, voluntary settlement and conciliation. Second one is adjudication, and third one, arbitration. So these are the various modes of industrial disputes. The settlement of industrial disputes broadly divided into 3 categories. First one is voluntary settlement and conciliation. Second one is adjudication, and third one is arbitration. So we will discuss one by one. First one is conciliation. The conciliation authorities that make use of conciliation as a method of settlement of industrial disputes are as follows. First one is Works Committee. The second one, Conciliation Officers, and third one, Industrial Tribunals and National Tribunals. So Works Committee, this act encourages voluntary settlement of disputes through Works Committee, whose object is to remove causes of friction between the employers and workmen. So Works Committee provides a voluntary settlement of industrial disputes. Initially, the form of settlement may be voluntary or conciliation machinery only. So Works Committee, whose objective is to remove the objection, the dispute or friction between the workmen and employers. The next one is another conciliation. So you can say Conciliation Officers, Industrial Tribunals, and National Tribunal. So we will discuss Works Committee. In the case of industrial establishment in which 100 or more workmen are employed or have been employed on any day in the preceding 12 months, the appropriate government may, by general or special order, require the employer to constitute in the prescribed manner a Works Committee consisting of representatives of employers and workmen engaged in the establishment. So, however, that the number of representatives of workmen on the committee shall not be less than the number of representatives of the employer. As per section 3, in any industrial establishment in which 100 or more than 100 employees or workmen are employed or have been employed in any day of the preceding 12 months, the appropriate government may, by general or special order, require the employer to constitute a works committee to reconcile the disputes between the workmen and employer by way of incorporating representatives from both sides, employers and workmen. And the number of representatives of workmen in the works committee shall not be less than the number of representatives of the employer. The representatives of workmen shall be chosen in the prescribed manner from among the workmen engaged in the establishment and in consultation with their trade union, if any, registered under the Indian Trade Unions Act 1926. So the representatives of workmen in the works committee are chosen after consultation with the registered trade unions, if any, in that industry. And it shall be the duty of the works committee to promote measures for securing and preserving amity and good relations between the employer and workmen. And to that end, to comment upon matters of their common interest or concern and endeavor to compose any material difference of opinion in respect of such matters. So it is a responsibility of, or it is the duty of the works committee to promote measures for securing industrial peace, securing and preserving good relations between the employer and employee, and to comment upon the matters of common interest of the employer and employee, and endeavor to compose any material difference of opinion in respect of such matters. So these are the provisions related to works committee. The second one is conciliation officers. Section 4, conciliation officers. The appropriate government may, by notification in the official gazette, appoint such number of persons as it thinks fit to be conciliation officers charged with the duty of mediating in and promoting the settlement of industrial disputes. A conciliation officer may be appointed for a specified area or for specified industries in such specified area, or for one or more specified industries, and either permanently or for a limited period of time. So as per section 4 of the Industrial Disputes Act 1947, the appropriate government, by way of notification the official gazette, appoint such number, as many number of persons as it think fit, as conciliation officers charged with the duty of mediating and promoting settlement of industrial disputes. So the appropriate government may, by notification the official gazette, appoint as many number of conciliation officers as it think fit for acting as a middleman or mediating and promoting the settlement of industrial disputes. A conciliation officer may be appointed by the appropriate government for a specified area or maybe for specified industries, or for one or more specified area or specified industries, either permanently or for a limited period. The following are the duties of conciliation officers. First one, to hold conciliation proceedings. Second one is to investigate the dispute for the purpose of bringing about a settlement of the industrial dispute without delay. Investigate the dispute and all matters affecting the merits and the right settlement thereof. To send a report and a memorandum of settlement to the appropriate government. To send a full report to the appropriate government, setting forth the steps taken by him in case of no settlement is arrived at. So these are the duties of conciliation officers. The first one is to hold the conciliation proceedings. So whatever steps required for conciliation, to provide all such steps of conciliation. The second one is to investigate disputes. If there is an industrial dispute, for the purpose of settlement of the dispute without delay, the conciliation officers are required to investigate the dispute and all matters affecting the merits and the right settlement of the dispute thereof. So it is their responsibility to investigate and to reconcile and to resolve the industrial disputes without affecting the rights of the parties. And next one, to send a report and memorandum of settlement to the government. And after arriving at the industrial dispute resolution, a report and the understanding, the written agreement, a memorandum of settlement, that should be forwarded to the appropriate government. And in case the settlement is not arrived at, it is his responsibility to send a full report to the appropriate government. Describing what are the steps he set forth for solving or resolving the problem. So these are the duties of conciliation officers. The section 5, Board of Conciliation. The appropriate government may, as occasion arises, by notification in the official Gazette, constitute a board of conciliation for promoting the settlement of an industrial dispute. A board shall consist of a chairman and 2 or 4 other members as the appropriate government thinks fit. The chairman shall be an independent person and the other members shall be persons appointed in equal numbers to represent the parties to the dispute, and any person appointed to represent a party shall be appointed on the recommendations of that party. So as per section 5, central government, the appropriate government, as the occasion arises, if there is any necessity, by notification the official Gazette, constitute a board of conciliation for promoting industrial settlement and industrial dispute. The board shall consist of a chairman and 2 or 4 members, other members, as appointed by the appropriate government. The chairman shall be an independent person and all other members are equally appointed in equal numbers from the representatives of the parties of the dispute. That means we can say employer and employees. Then we will discuss next form of conciliation machinery. We can say courts of inquiry, section 6. The appropriate government, as the occasion arises, by notification in the official gazette, constitute a court of inquiry for inquiring into any matter appearing to be connected with or relevant to an industrial dispute. A court may consist of one independent person or of such number of independent persons as the appropriate government may think fit, and where a court consists of two or more members, one of them shall be appointed as the chairman. So, as per section 6, the appropriate government, if the occasion arises, by notification the official gazette, constitute a court of inquiry for inquiring into any matter appearing to be connected with the relevant industrial dispute. The court shall consist of one independent person or of such number of independent persons as the appropriate government may think fit, and where a court consists of two or more members, one of them shall be appointed as the chairman. Then second part is adjudication machineries, section 7 to 9. Section 7, labor courts. The appropriate government may, by notification of the official gazette, constitute one or more labor courts for the adjudication of industrial disputes relating to any matter specified in the second schedule, and for performing such other functions as may be assigned to them under this act. A labor court consists of one person only, to be appointed by the appropriate government. So as per section 6, in order to reconcile or in order to resolve industrial disputes, the appropriate government may, by notification of the official gazette, constitute one or more industrial tribunals to any matter specified in second schedule of the Industrial Disputes Act 1947, and for forthcoming such other functions as may be assigned to them under this act. A labor court shall consist of one person only, to be appointed by the appropriate government. Then section 7A, tribunals. The appropriate government may, by notification of the official gazette, constitute one or more industrial tribunals for the adjudication of industrial disputes relating to any matter, whether specified in the second schedule or the third schedule, and for performing such other functions as may be assigned to them under this act. The tribunal consists of one person only, to be appointed by the appropriate government. So as per section 7A, the appropriate government may, by notification of the official gazette, constitute one or more industrial tribunals for the adjudication of industrial disputes related to any matter specified in the second or third schedule, or for any other purpose or any other functions as may be assigned to them under this act. The tribunal consists of one person only, to be appointed by the appropriate government. Then section 7B, national tribunals. The central government may, by notification of the official gazette, constitute one or more national tribunals, industrial tribunals, for the adjudication of industrial disputes which, in the opinion of the central government, involve questions of national importance or are of such nature that industrial establishments situated in more than one state are likely to be interested in or affected by such disputes. A national tribunal shall consist of one person only to be appointed by the central government. Or a person shall not be qualified for appointment as the presiding officer of a national tribunal unless he is or has been a judge of a high court. So as per section 7b, the central government, by notification of the official gazette, constitute one or more national industrial tribunals for adjudication of industrial disputes which are, in the opinion of the central government, involve question of national importance or such nature that industrial disputes are situated, industrial establishments are situated in more than one states, or likely affect the interest of more than one state. A national tribunal shall consist of one person appointed by the appropriate government, and no person shall be qualified for appointment as the presiding officer of a national tribunal unless he is or has been a judge of a high court. So only high court judges are eligible to act as a presiding officer of a national industrial tribunal. Then we will discuss award and settlement. The report of a board or court shall be in writing and shall be signed by all the members of the board or court as the case may be. The award of a labor court or tribunal or national tribunal shall be in writing and shall be assigned by its presiding officer. Publication of reports and awards, section 17. Every report of a board of conciliation or court of inquiry, together with any minute of dissent recorded therewith, every arbitration award or every award of a labor court, industrial tribunal or national industrial tribunal shall, within a period of 30 days from the date of its receipt by the appropriate government, be published in such manner as the appropriate government think fits. So as per section 17(1), publication of report. Every report of board of conciliation or court of inquiry or tribunal or labor court or industrial tribunal or national tribunal shall, within a period of 30 days from the date of receipt of such award, the appropriate government, be published such report in such manner as the appropriate government thinks fit. The section 17A, commencement of award. Award to become enforceable on expiry of 30 days from its publication. The appropriate government may, if it is of the opinion, in any case where the award has been given by a labor court or industrial tribunal in relation to an industrial dispute to which it is a party, or the central government may, if it is of the opinion, in any case where the award has been given by a national tribunal by notification in the official gazette, declare that the award shall not become enforceable on the expiry of the said period of 30 days. The appropriate government, or as the case may be, The central government shall do so if it is expedient on public grounds affecting national economy or social justice to give effect to the whole or any part of the award. So section 70, as per section 17a, award to become enforceable on expiry of 30 days from its publication. The appropriate government is of the opinion that in case where the award has been given by a labor court or an industrial tribunal in relation to industrial dispute, or the central government has it in the opinion, in any case where the award has been given by a national tribunal by notification of the official gazette, declare that that award shall not become enforceable on the expiry of 30 days from the set period of 30 days. The appropriate government or as the case may be, the government shall do so. The government used to say that award is no need to enforce, no, it shall not be enforceable on the following grounds, public grounds. First one is that will affect the national economy, or that will affect the social justice to give effect to the whole or any part of the award. Rejection or modification of award within 90 days. Where any declaration has been made in relation to an award under the provision to section 17a subsection 1, the appropriate government or central government may, within 90 days from the date of publication of the award under section 17, make an order rejecting or modifying the award. So central government is having all the right to rejection or modification of the award of any adjudication authority within a period of 90 days. Then penalty for breach of settlement or award, section 29. Any person who commits a breach of any terms or any settlement or award which is binding on him shall be punishable with imprisonment for a term which may extend to 6 months, or with fine, or with both. Where the breach is a continuing one, he shall be punishable with a further fine which may extend to rupees 200 for every day during which the breach continues after the conviction for the first offense. So in case the party, any person in a settlement or award who is breach of the terms or settlement of the award shall be punishable with imprisonment for a period of 6 months, or with fine, or with both. Where a situation that the breach is continuing in nature, he shall be punishable with a further fine which may extend to rupees 200 for every day during which the breach continues after the conviction of the first offense. Conditions precedent to retrenchment of workmen, section 25 subsection F. No workman employed in an industry who has been in continuous service for not less than 1 year under an employer shall be retrenched by that employer until the workman has been given one month's notice in writing. The notice must indicate the reason for retrenchment. Further, the workman cannot be retrenched until the period of notice has expired. or the workman has been paid in lieu of such notice wages for the period of the notice. This condition is mandatory as and non-compliance with it will render retrenchment illegal. The workman has been paid at the time of retrenchment compensation which is equivalent to 15 days average pay for every completed year of continuous service or any part thereof in excess of 6 months. Notice in the prescribed manner is served on the appropriate government or such authority as may be specified by the appropriate government by notification in the official Gazette. So as far as retrenchment, the conditions of retrenchment of workmen is concerned, as section 25 subsection F defines, no workman employed in any industry who has been continuous service for not less than 1 year. So any person who is employed not less than 1 year, that means you completed 1 year or more than 1 year, an employer shall be retrenched by that employee. An employer shall retrench by the employer by satisfying the following condition. A workman has been given 1 month's notice in writing, and the notice must indicate the reasons for retrenchment. What are the reasons or basis of retrenchment? And moreover, the workman cannot be retrenched until the notice period or the workman has been paid in lieu of such notice wages for a period of notice. So the workman is required to provide, the employer is required to provide 1 month's notice. It must clearly mention the basis or the reasons for retrenchment. And see, during the 1 month notice period, no employee shall be retrenched. And if in case the employer wish to retrench him, the employer is required to provide 1 month wages for the notice period. And this condition is compulsory, it is mandatory, and non-compliance of this condition that will treat the retrenchment as illegal. The workman has been paid at the time of retrenchment compensation which is equivalent to 15 days average pay for every completed year of service or any part thereof in excess of 6 months. So the employer is required to provide 15 days average salary of each and every completed years of service. Notice in the prescribed manner is served on the appropriate government or such authority as may be specified by the appropriate government. The principle of last come first go, section 25G of the Industrial Disputes Act applies the rule of last come first go to retrenchment. Thank you for watching my channel. Please do not forget to subscribe our channel. Please click the bell icon near to the subscribe button. You will get notification when we upload new videos. Thank you.